Madam Speaker, it was in 1887 that Lord Acton in England wrote to Bishop Mandell Creighton, and he said this in his letter: power tends to corrupt, and absolute power corrupts absolutely. Great men are almost always bad men. And this he wrote, he said, is because he was a critique of the Roman emperor who declared themselves God, and equally a critique of Napoleon Bonaparte, who declared himself emperor. And during those days, corruption was rife. People in those days were trading with all sorts of things simply to get an extra portion of land or an extra portion of farm in order to enrich themselves. Honorable Ganu wants effective sanction to be the order of the day, and I can assure him that by virtue of this bill, effective sanction is the order of the day and will be the order of the day. Madam Speaker, politics is all about integrity, is all about honesty. But truth it is to say that, like in many other countries, in Mauritius as well, there was a time when corruption was out of control prior to 1982. And that's why the campaign of the then MMM, led by Saneru Jagnat, was that they should tackle corruption. And post-1982, the campaign in Mauritius about a law in relation to declaration of assets, and anti-corruption law became intensified. And it was in 1985, I'm not going to go in detail into the historical perspective because Honorable Ganu has dealt with the historical perspective quite ably. So it was in 1985 that the first declaration of assets law was passed in the House. At the time, of course, there was critique about the law, but it was a bill, a law in 1985 that suited its purpose and had its result. Because then politicians were aware that there is some degree of control, and in fact, it was more of a signal of deterrence. But I can say from experience that I have known politicians who yesterday were, for example, school teachers or secondary school teachers, and after 5 years of being in office, he started to own properties worth multi-million rupees, businesses, and lots of land all over the island. So these kind of politicians, in fact, gave politics the bad name that we hear today on the ground. As I said, politics is about honesty. Politics is about integrity. And if we don't have honesty, no integrity, please don't step into politics. I know many people even now, and what is shocking is that young people, they tend to believe that embarking in politics is an easy way to become rich, because they have a perception that once you become a politician, you actually have been elected and you're in parliament, you become a minister or an MP, then it is an opportunity to technically steal money. But that's wrong. There are a few who have done it, but they have not been caught, unfortunately. Or fortunately for them. Can anyone explain objectively, really objectively, how a man who has never worked in his life, never practiced as a doctor, not even a practicing barrister in Mauritius, never practiced law elsewhere in other jurisdictions, was found to have 220 million rupees in his house, including pristine US dollar. How? Apparently the dollars, I'm told, they were still warm.
Virgins dollars.
So it is.
That's so noble right now. I would advise you not to go and to make unwarranted comments, but to stick yourself to the essence of the bill.
I'm ever so grateful, Madam Speaker. I'm trying to put things into context, into perspective. Because of the few bad men of the kind described by Lord Acton, we all get a bad name. Now, I can say this. Nowadays, very rarely you will see people from low-income background, humble family background, coming into politics. Why? It's because a few who have got lots of money, who can juggle around money, are embarking into politics. And therefore, those with less able money-wise in background will not be able to join in. So, against this background now, let's look at what this bill is all about. The bill is sending a strong signal that if you acquire assets for which you can't explain, whether you are a politician, elected MP or not, whether you are a councillor, an executive person holding office in local council, you are bound to make a declaration, and the declaration of assets that we have today reflect the reality of the kind of assets these days normally people possess. True it is to say that in 1985, the kind of assets Mauritian used to hold were bank accounts, were overdrafts, were immovable properties, and were motor vehicles. But since 1985 to 1991, and then to now, the definition of asset has changed considerably. And that's why we have got a number of products that have been listed in the definition of assets, including securities, and I take issue with the argument raised by Honorable Ganu in relation to the definition of securities, because I think that securities is properly defined in the Securities Act, and here the securities includes stocks, bonds, treasury bills, or other units held in Mauritius or abroad. So the definition of securities is well stipulated here, and also this definition is complemented by the definition of securities in the Security Act. And Honorable Ganu, in dealing with the issue relating to securities, also stated that other linked product, example, other investment like life insurance and other products. But this is also covered if we look at the bill. If we look at Roman numeral 8 of the interpretation section, section 2, Roman numeral 8, states that asset held by a person for or on behalf of the declarant in the declarant capacity as ultimate beneficiary. So even if you have an insurance policy and you are the beneficiary of that insurance policy, whether a life insurance or otherwise, then there is a duty to declare. So I anticipate, for the purpose of construing the interpretation or the interpretation of this statute, I anticipate that insofar as securities is concerned, and the points raised by Honorable Ganu in relation to insurance policies is covered by this provision. Now, Prime Speaker, we have heard a lot of criticism against ICAC. And to criticize, it's very easy. To build up a perception about a particular institution is the order of the day with the opposition. They make believe that ICAC is protecting the government when they speak like that. They try to convey the message to the public out there that ICAC is not doing its job properly. But let me remind the opposition, whenever there has been a complaint to the ICAC against members of this government, ICAC has investigated members of this government. And when I stand here, I see my Colistier, Honorable Lakshmina Raidu. He lost his portfolio of Ministry of Finance because of an allegation. And what was the allegation? That he was involved in a corrupt act. There were investigation after investigation on him. His reputation was tarnished. And his reputation is still rest tarnished. He was investigated. eventually what was the outcome? It was all a hoo-ha. Honorable Raj Dayal has been investigated. No, I'm just saying, it's not...
Better not mention. Honorable Rutnah, you can mention the case, in fact, is in court. You have mentioned it, but don't go deeply into the matter.
Speaker, what is wrong for me to say? It's in public domain. What is wrong for me to say? Where is the... Yes,
Madam Speaker.
Honorable Rutnah, I have given my ruling. I've told you that the case is in court. Don't go deeply into the matter. You mentioned the case of Honorable Dayal. What is in public domain is in public domain. But please, don't make any statement which can have an impact on his case. Please.
I'm not making any statement. I'm not...
Order, Madam Speaker. Madam Speaker, it's not a question of giving way. On a point of order.
I have given my ruling on that matter. And for me, if it's another issue and it's not related to the case of Honorable Dayal, then I will allow you the floor.
It's related to a matter that you are maybe not aware of, and I'm duty-bound to inform you, that Honorable Rutnah is also the lawyer of Honorable Dayal, and therefore is conflicted. He cannot come to use this August Assembly pour faire sa plaidoirie pour son client, qu'il le garde pour le faire dans une cour de justice. C'est tout.
This comes back to what I have just said, Honorable Mohammed. I have just given my ruling on this matter. Being aware of all the facts of the case, I have asked Honorable Rutnah not to go deeply into this matter. He's mentioned that case, but not to go deeply into that matter.
Mr. Speaker, I know my duty as counsel. I know my duty.
But Honorable Rutnah, are you disputing or defying what I've just said, please? I have given my ruling, and I think that my ruling is final on this matter.
Mr. Speaker, there is nothing that prevents me just to mention. I'm not going into deep into it. And I'm not going to take lessons from someone who does not make the difference between a unitary state and a federal state, and who says that parliament is not supreme or neither constitution is supreme. And I'm not going to take lessons from someone who keeps asking questions about BAI while being counsel for BAI. So
Honorable Rutnah, having said this, I think that my ruling is final, and that you will have to bow to the ruling I have given. This is the matter, and I don't think that you would contest or defy the authority of the chair in this matter.
I am not, Madam Speaker. But let me say it again, that the ICAC has always investigated on members of the government whenever there has been complaint against members of the government.
This is another statement.
Yes.
Which is correct.
But I was giving example, I was not going into detail. And ICAC will always investigate. ICAC will also investigate on the opposition. But the problem with the bill, the problem with the bill is not retrospective to take account from what happened in this country since 2010 onwards. Then we would have known how many people have enriched themselves whilst in government. But in any event, Madam Speaker, the bill.
Honorable Mohammed, please. Yes. Honorable Mohammed, from a sitting position, I wouldn't allow you to interrupt the honorable member.
Madam Speaker, and you have noticed that whenever you are on your feet, I tend to respect the chair I sit. I don't argue with you. Yes. Unlike you, Honorable Duval, unlike you. Yes. Yes. But because you are making Honorable Duval from a sitting position is making comments, and Honorable Duval should know that when he was speaking, when Honorable Duval was speaking, I was listening. I was not making comments. but they tend to make comments all
Can
the
we
time.
have some order on this side of the House also and allow the honourable member to proceed with his speech?
Honorable Duval always make comments. Honorable Mohammed always make comments from sitting position when I'm on my feet. When they are on their feet, I listen to them. Why I listen to them? So that I contribute to the debate, so that the people of Mauritius can listen to what I have to say. But whenever I am on my feet, they don't have the decency even to extend the courtesy to listen. But anyway, coming back to the bill, Madam Speaker. Coming back to the bill, I don't subscribe to the criticism that has been leveled against the ICAC. And let me tell the honourable member who has criticized ICAC, who doesn't know whether Parliament is supreme or not, or whether, and he doesn't even make the difference between a unitary state and a federal state, that ICAC is not a prosecuting authority. ICAC doesn't prosecute. ICAC investigate and send its investigatory dossier, the file, to the Director of Public Prosecutions. The Director of Public Prosecution, by virtue of Section 72 of the Constitution, he decides whether to prosecute for an offense under ICAC or not. So as a lawyer, he should have known that, but I agree that he's quite junior and he's still learning. So in any way, Madam Speaker, now I am going to deal with the second critique of Honorable Ganu. Honorable Ganu, as always, a man who has always measured his criticism. And I respect people who criticize within a certain parameters. And that's constructive criticism. It's not politics à la outrance that Honorable Ganu has done today. Honorable Ganu made a point that parliamentarians ought to have declared, or there should have been a provision in this bill, that parliamentarians who are professional should declare the remuneration and gratuities for professional fees. And I think he is a bit confused insofar as what the Declaration of Assets Act is all about. Declaration of Assets Act on its own as a single legislation is not designed to deal with all corruption offenses in the country. And that is not even the spirit of this bill. And nowhere in the world Declaration of Assets deal with all corruption aspect of institutions and authorities. There is provision in our other laws that those who work has got professions and act for any institution, whether government or otherwise, or work for private clients, they should declare their VAT and their income tax. So once that is done, then there is no need for declaration because you are declaring your VAT, you are declaring your return annually, and if you fail to do so, you commit an offense under the MRA Act, and you are likely to be prosecuted for that. So I don't think that the suggestion Honorable Ganu has made is a suggestion that can be taken on board because there is already legislation. We do not want to make the present bill sound cumbersome or make it sound like this is the only bill that is going to deal with act of corruption. And then also Honorable Ganu dealt with the issue of assets and liabilities. And I know, Madam Speaker, you tried to point out the definition of assets and liabilities. And perhaps for record, I should clear the doubt that is in the mind of Honorable Ganu, and that would suffice, I anticipate. Perhaps if I could take everybody to the definition section, section 2A, where there are a number of definitions, and amongst others, there is a definition at page 4 of the word declaration. The word declaration means a declaration of assets and liabilities referred to in section 4. So when you're declaring your assets and your liabilities. Now, section 4 also says obligation to make declaration of assets and liabilities. The obligation is not only to declare your asset, but also to declare your liabilities. And if I may, for the sake of the record, read subparagraph C, subsection 3, together with what follows. Then, after his seat become vacant, pursuant to section 35 of the Constitution, section 19 of Rodriguez Assembly Act, or section 40 of the Local Government Act, as the case may be, make a declaration of his assets and liabilities with ICAC, including the assets and liability of his spouse and his minor children. So, what it is all about, it's not only declaring your assets and liabilities, it's now extended to your assets and liabilities to your wife and your children. But does that say mistress here? No, it doesn't. Yes. But I anticipate they would be holding assets on trust for beneficiaries, which also will be smoked out according to this bill. So, Madam Speaker, in relation to the point that Honorable Ganu also made about clause 6, fresh declaration, as to why in subsection B, E and F, paragraph E and F, in relation to fresh declaration regarding judicial officers and executive officers, why they have to declare on a 5-year basis, not as with other categories. I anticipate the explanation is very simple. Judicial officers and executive officers, they are public servants. They are public servants. They hold their post permanently, and they are not like us, holding our position as parliamentarian for a period of 5 years. And if the will of the population wants us to come back, then they will renew our mandate for a further period of 5 years. So the explanation is simple, that we, of course, will have to do it according to what the law says now at subsection 6A. And for those who are in permanent employment, they would, of course, make it over every interval of 5 years. And much has been said by the leader of the MMM and also by Honorable Ganu about how the disclosure will take place. True it is that it's not expressly said in the Act that how disclosure will be made. But disclosure of assets and liabilities is something which belongs to the person. It's private. And there should be some limit as to how it should be disclosed. I am for transparency. I am for honesty. But there are some people who might use information to abuse. You know, nowadays, we get a section of the press that if you go and fill petrol at the petrol station, you get it for free. You go to ISPA, you buy 500 rupees worth of articles, you get it for free. You go to Intermart, you spend 1,000 rupees, you get it for free. So there is a danger out there that if information is available to people so easily, especially people who are likely to abuse the information, because they believe that if you fill petrol in your car, you will get the people will get it for free, then that information will be available to abuse. There should be some mechanism, and I'm sure if tomorrow there is an investigation, let's say, for example, anyone in this house, I am sure there will be some mechanism put in place to ask for disclosure of the assets and liabilities of the member who is the subject of the investigation. But let me refer the House to a European Court of Human Rights judgment in 2005 in relation to the law of privacy, and which deals with declaration of assets. It's in the case of Wypish against Poland, a Polish national, a case on which the judgment was delivered on the 25th of October 2005, application number 2428/05. The European Court of Human Rights rejected the complaint of a local councillor, member in Poland, who refused to submit his assets declaration, claiming that the obligation to disclose details concerning his financial situation and property portfolio imposed by legislation was in breach of Article 8 of the European Convention of Human Rights. The court found that the requirement to submit the declaration and its online publication were indeed an interference with the right to privacy, but that it was justified and comprehensive scope of information to be submitted was not found to be excessively burdensome. So on one hand, the European Courts of Human Rights recognizes that there is a problem, it's concerned the right of privacy, but on the other hand, it says that it's not burdensome. So there must be some degree of limitation so that those who tend to abuse will not abuse the information which is in public domain. Madam Speaker, I see the time, and I have to simply say something about conflict of interest. There is always, when you are in public domain, when you are exercising public duty, that people have to be careful with any conflicts that may arise during the course of their tenure. And that is why we have provision in the bill that is firstly going to deter anyone to get involved into any act that is likely to enrich him. So any act, including those that might influence a contractor, for example, to give contract, is an act which is under surveillance in this bill if the member, if the MP who is trying to do something untoward. So it's not necessary, in my opinion, to burden this bill with code of ethics and with conflicts of interest, because as the act has been formulated, as the bill has been formulated, it is understood that act of conflict of interest is taken into account. But in any event, the law on conflict of interest is defined very well in the Prevention of Corruption Act. So, this act on its own is not an act, this bill on its own is not a bill that deals with the whole area of corruption. There is the law on corruption under ICAC. There is the law in relation to unexplained wealth. And now we have this law coming in relation to declaration of assets. Madam Speaker, I would like to extend my gratitude to the Honorable Prime Minister and all those who have contributed towards the drafting of this legislation, because it is the first legislation in modern Mauritius that deals with a modern asset and in a modern way to deter those who hold power to be careful. And the words of Lord Acton will not reflect reality as of now once this bill is gazetted. Thank you, Madam Speaker.